All right. So transferability is an important feature. And then, okay, so you establish a company. You agree on how much you're going to get, how many shares you're going to get, how much you're going to pay, and so on and so on. Now, then you address that this stock cannot be transferred. Okay, only permitted situation is this, and you have to define it and all that. Now you want to say something about the management of the company, right? How will this going to be managed? You have to say a board of director, how the board of director, who's going to be the, how are they going to be nominated, and so on, how are they going to operate, and the shareholders meeting, how they are going to do it, etc., etc. Okay? So as you can say, section 6 about board, and the section 7 is about managing director, important thing. And then Article 8, basic corporate operating, books and records, and then something about debt financing, related agreement, confidentiality, and then termination, and then boilerplates. So let's go over it. Each party shall exercise the respective voting rights in the company and take such other steps as is necessary to ensure that the board of directors of the company shall consist of, here it says 3 members. Obviously, when you say 3, somebody is going to appoint 2, and therefore you know that this will be not in a 50-50 situation. One of the guy will be majority, the other guy will be minority. Okay? But if it's say, let's say even number 4, maybe it's different. That of such members, 2 shall be nominated by Korean party and 1 member by domestic party. All right? And each shall procure the nomination and election of the members nominated by the other party. And, okay, so this is how it is agreed. But it can be changed depending on the situation. It could be 50-50, etc. Right? The important thing is, if I want to change the guy who I'm nominated, I should have the right to freely change it. But however, changing it requires shareholder approval, so you want to make sure that the other guy approves my choice. Okay? If any party wishes to change any of its nominated director, with or without cause, that's important. Why there is such a statement, say, with or without cause. I will explain it. The other party shall vote its shares accordingly, provided that if such dismissal is without cause, the party proposing the dismissal shall indemnify and hold the company and the other party harmless for any and all damages or other expenses that may arise from such action. Now, the reason with or without cause under Korean Commercial Code, okay, under KCC, all right, appointment of directors is by ordinary resolution of shareholders. However, dismissal of a director before the term is it requires a special resolution. Okay? Right? Special resolution. Now, you can dismiss it. You have the right to dismiss. If you are a shareholder, by having a special resolution, supermajority vote, you can dismiss a director at any time. However, if you dismiss it without cause, right, then the Korean Commercial Code says the director has a claim. If the director's term was, let's say, 1 year, okay, the maximum term being 3 years, okay, but it could be 1 year, right? If it's a 1 year and he's removed without cause as of May 31st, then out of 12 months, he only received 5 months compensation, and there's a 7 months compensation that is unpaid for. Now you are free to remove me, but you have to pay me. You understand what I'm talking about? You have to pay me. You have that claim. So that's why you can change, you can change it, and you nominate, okay, you shareholder, you nominate, we agree on the number 2 and 1. But if anybody who nominated the director wants to change it, I will go along with you. I will vote in accordance with it. But if it's without cause, and that guy makes a claim to the company for the rest of the term of the compensation that I'm entitled to, then because it's your nominated director, you should be responsible for it. You understand? Okay, that's how it goes. That's KCC. I don't know about the other country, but I'm sure that there is such a concern, probably in many countries, because we follow the civil code. But we also adopted our, KCC, a lot of features from common law jurisdiction, right? So I'm sure that there could be some of such concerns. That's why this, if it's going to be established in Brazil, you have to ask the Brazilian lawyer to take a look at it to see whether these are in line and enforceable and valid under your law, Anyway. And then if it's vacant, you will vote, same thing. Meeting of the board may be called at the request of a director when he deems the same to be necessary or advisable. Meetings of the board of the director shall be held at least semi-annually. So, then you want to say how often that board of directors should meet. And obviously, as often as necessary, but at least at the minimum, we have to meet twice a year, 3 times a year, something of that sort. Now it's the meeting potential. Yeah, to the extent allowed by law, director of the company may participate in a board meeting by means of teleconference, where all directors participating in the meeting can simultaneously hear each other, and such participation shall be deemed to be participation in person. Now, this is particularly in light of Korean law. This board meeting has to take place. Whereas, for example, in the United States, if all directors agree, they can take a resolution by written. Okay, provided that all the directors agree, you don't have to have a meeting. Just sign the resolution. Okay, that's possible. But still under Korean law, that is not possible. The reason being that Korean, law still states that, you want directors to be able to discuss something, before coming into a conclusion. So we don't yet allow this written resolution by board of directors. But we are going to, in light of the global situation, we are going to make it easier for you to participate, You can participate at home or in another country, whatever, by teleconference. That's as far as we go. But I expect that sooner or later the KCC will change, that they will allow the written resolution by all incumbent directors. Okay, not majority, all. Okay. All actions and resolutions taken at the mode of shall be adopted by a majority vote. Now you have to then discuss about majority vote of all directors of the company unless otherwise required by this. Why? Because this agreement was written for this to be in advantage of the supplier who owns the majority here. So majority means 2. The guy who is nominating 2 can always outvote the other guy, right? Obviously, if you were the other guy, you would not want it. You'd probably not want it. Anyway, they would probably say, let's make the director, instead of 3, let's make it 5, and then at least you want 80% of the, or 4 out of 5 directors or something. Then he will virtually get all veto rights, okay, by changing this requirement, right? And who appoints the chairman? Because chairman is usually the guy who convenes the meeting, right? But even if the chairman fails to convene, obviously, then another director could do it, but, it's about the chairman. Right? It doesn't specifically state about the shareholders, but you could have similar provisions about shareholders, and say anything that would be necessary, how the ordinary meeting of shareholders go, what would be the quorum, what would be the voting in order to pass a resolution, and if the notice is given, how long such notice should be given, and so on, right? Those matters. Here, obviously, we don't say particularly about the shareholders, perhaps because, by controlling the board, you can probably control everything. So, anyway, managing director. This is so-called the representative director, whose role is to represent the company and shall be appointed by the board of directors. Now, obviously, if you are a minority, you want to move this to a shareholder decision. If you agree to 2-to-1 board member, you want to pull it off to the shareholder, and not only to the shareholder, but have the shareholder veto right or something of that sort, right? Because appointing the representative director, managing director, is important. Then company shall have officers appointed by the board of directors, etc. It's because here the assumption is, since the Korean party will be the investor investing in as a foreign party, all right, most likely the CEO will be nominated by the other guy who knows the system, who knows the local kind of business. In that sense, we want to have a control of being able to change if we don't like it. So do it as the board. And then, what about the other officer? For example, CFO and things of that sort. We don't want that offices to be appointed by the managing director, right? You could have it as other officers can be appointed by the managing director. If the managing director is to be nominated by this guy, that guy would probably have the draft like that. But since this situation assumes that the CEO, the managing director, is likely to be appointed by the other guy, you want other kind of officer position, imam position, to be appointed by the board of director because we control the board, things of that sort. Okay? That's how it goes. All right. Then basic corporate and operating policy. All right. So they want to do it set forth in the article, meaning the articles of association. The parties agree to vote their shares and cause their nominated shareholders and directors. Their nominated shareholders. Doesn't make sense, right? The parties means shareholders, so nominated shareholder doesn't probably. That's probably a typo. Nominated directors to effectuate such policies. Okay, during the continuance of this agreement, the parties shall maintain the ratio of shares held by them as set out in Article 4.1 of the company, respectively, except as provided in Article 5.2. So once they agree on a share ownership, okay, shareholding structure, then they want to maintain it. Okay, they want to maintain it, but except as set forth in 5.2, And 5.2 is transfer to an affiliate, obviously. Okay? So maintenance is important. Otherwise, then the share ownership could change, and the whole thing could change. Whole management structure could change. The parties agree that the company shall distribute dividends as permitted by laws and recommended by board of directors, profits resulting from the operation of the company. The parties shall cause the company to distribute dividends as recommended by the board of directors. Now, obviously, this guy controls the board, so they want to say it's recommended by the board of directors. The board of directors shall review and approve annual budget and plans, okay, prepared by the managing director, which may be revised from time to time. Any increase in capital must be approved by shareholders holding not less than 2/3 of the entire issue share capital from time to time. Now here, usually you want a certain kind of supermajority, vote for any increase because you don't want the dilution of a share, unwilling. However, if you are controlling shareholder, obviously, then, 2/3 means if they have 2/3 or whatever, it's assumed that if it's 70-30%, let's say, then obviously this guy has more than 2/3, so he can pass whenever he wants to. But if it's, let's say, 60-40, then 2/3 require this guy's veto right. Okay? Now, books and record according to international accounting standard. So, and you could say, particularly the international accounting standard, because, obviously from Korean party's perspective, you don't want you are not familiar with the local law, so you want that to be, international accounting standard that you're probably familiar with, like Korea, the international accounting standard accepted by Korea, KAIFLS, right? And things of that sort. So there's that international accounting standard, which the people could be familiar with. So if you are a foreign investor, you probably want to do that rather than local GAAP, especially if you are unfamiliar. Then you have to state the fiscal year. Now you want this fiscal year to match your fiscal year if you're a foreign investor. And because, especially if this company is consolidated in your accounting statements. This guy, if this guy have a majority, then it's consolidated, right? Now then there's a debt financing, the way that the company will need money. So you have to have some provision of how to approve. Obviously, you can say capital increase and parties participate in accordance pro rata with their capital, with existing ownership, but ratio. But however, sometimes you don't want to do that, and the company could go to the debt financing. Shareholders do not keep on just contributing money. If the company is able to get debt financing, then they should get debt financing. So, but it depends on the situation, but you have to, it is wise to say something about that. The company shall obtain debt financing under its own responsibility. Why? What's its own responsibility? Because that means shareholders do not want to guarantee that debt financing, right? If necessary, which the decision of the board of directors shall be final and conclusive, the party shall guarantee any kind of debt financing for the company at the ratio of shareholding owned by each party respectively. So obviously, since this guy controls the board, he says whenever the board deems it necessary, then we have to give guarantee pro rata in accordance with our ownership, right? other related companies, other related agreements. So, for example, there's a, this exclusive distribution agreement would be necessary later on when the JV is doing enough, and it makes sense to manufacture locally. Okay, maybe they have a cheaper labor. So if you give, and then you can produce products more cheaply, and therefore, it'll be more profitable. If they decide, then there would be licensing agreement where they allow the JV to be able to manufacture and so on and so on. Okay? If there's a definitely foreseeable agreement that is related to it, then you'd attach it to this agreement. Then there's a confidentiality, especially this guy. Since this guy is a producer, this guy is a supplier, this guy has more confidential agreement relating to the product and so on. Whereas these guys will probably, that's why then you want to have more detailed agreement on confidential information. All right, such as trade secret and so on and so on. Now then, term and termination. Now this this one is without term. Usually the JV continues unless the parties decide to terminate or parties agree to terminate. So when can they terminate? When they agree. It's A. And then another thing is, if one guy breaches its obligation, okay, and fails to cure after notice, that's C. Okay. In B, it states, if it gives a long stop date stating that if the company, JV company, is not incorporated without liability. Okay. If the incorporation company has not occurred by a certain date, then you just forget it. Okay. But if the incorporation by the company occurs without breach, okay, of the other party, then the breaching party cannot obviously terminate. Now, this is usually a situation where you enter into this type of agreement, but usually there is a condition precedent. There has to be some kind of satisfaction. For example, a merger notification, that a business combination report that you have to file. And if that business combination report does not come out and it's not cleared, then obviously it drags on for a certain period, then you have to say, then we have to decide. Okay? So that is that. And then if the other guy goes bankrupt, obviously you want to be able to end this relationship. All right? You don't want to get married with somebody who is bankrupt and unable to do anything. And then if there's a force majeure, obviously, usually, okay? And the force majeure situation continues for more than 90 days, 3 months. Or it could be longer or shorter, but usually 90 days is very common. Because now force majeure is a situation where nobody is responsible. Even though that guy is not fulfilling his obligation, he's unable to do so under the situation. It's not under his control. But however, if that situation continues for longer, then the other guy should be able to terminate. Okay? That's what it means. So what if this is terminated? What happens? Especially under what situation? If it's a bankruptcy of the other guy, or if this is a breach due to breach, what if then obviously non-breaching party should have some kind of rights. The breaching party should have some kind of penalty for breach, right? So one option is that if the other guy, non-breaching party, wants to continue this alone, okay, then he has the right to purchase the shares, the other guy, the breaching guy's shares, at below fair market value. Okay? So 80% of fair market value. Or I just want to dump my shares to you. You do whatever you want to, but you buy my shares at 20% markup of the fair market value. So that's usually call or put option. Since this is below or above fair market value, in Korea, if this JV was to be conducted in Korea, since it's either party, if non-resident has such a right, then, it's reportable. So you have to file a Bank of Korea filing. To have this kind of right. It's below fair market value, and you have an option to sell or buy, right? That option is a derivative. So you have to make some kind of derivative filing to the Bank of Korea. The Bank of Korea filing is required under Korean law to be filed before signing of this agreement. But that's Korea. Other countries may not have that kind of thing. But this put call option is usual way. Or C is just you require the other guys to liquidate. Don't buy shares, just liquidate. Okay. And then some, usual kind of a provisions. Now, miscellaneous provision. Now, miscellaneous provisions are important in its own way. You have to have a notice provision, otherwise it's difficult where to give notice. And what method of notice is the right notice. So you have to say whether it has to be by mail, or it has to be by personal delivery, or it can be done by fax, or it can even be done by email. It's depending on. And if it's done by email, when should it be deemed to be delivered? Fax, when should it be deemed to be delivered? If it's by mail, when should it be deemed to be delivered, and so on, right? Okay, so if you take a look at page 26, notice delivered by hand. Personal delivery shall be deemed received upon delivery. Notices sent by postage paid register mail shall be deemed to be received 1 week after sending. Assuming that this is an international transaction, it takes 1 week, The notices sent by fax shall be deemed received at 1 business day after the time, because if it's sent on Friday night, okay, is it deemed to be received on Friday night or when? 1 business day after the time the transmission is recorded at the facsimile machine of the sender or at the email server of the recipient, whatever. I mean, there's various kinds of it, but you do it whatever is preferable and right for you. But this is one way of expressing it. I think the thing to notice is that you have to say precise mechanism of when it is deemed to be delivered, right? And so you send it. When you send it, obviously you want to have a proof, okay, of sending. That's why usually you send it as a register mail, or upon delivery they usually get the signature of the recipient, okay, or things of that sort. Okay, entire agreement just means that this entire agreement is that what we have agreed here concludes that this is a conclusive matter on the subject matter. There is no other conflicting agreement, no oral agreement, okay? It supersedes all other oral agreement. This is to say that if the other guy claims that there has been some other agreement there, forget it, okay? This supersedes, okay, everything on the subject matter. severability is, for example, if one of those provisions become unenforceable, that unenforceable, invalid provisions should be separated so that it does not make this entire agreement ineffective. If a provision is invalid, just that provision will be held invalid. That's what it means. Okay? Amendment, obviously, you want to make this any kind of amendment to be written, right? Counterparts, control language, you know. And then 14.6 is independent contractor, says relationship between us is just an independent contractor. It's not an agency relationship. You cannot represent me, for example, you know. So nothing in this agreement shall be construed constitute either party as agent. Okay? And neither party shall bind or attempt to bind the other party to any contract or performance. And then assignment, obviously, it is not assigned unless consent of the other party, or assignment pursuant to 5.2, okay, is possible, or things of that sort. Okay, so that's basically a very, very brief kind of a joint venture agreement, but you just know by structure of it, there's a definition, then there's a, you know, how to establish how much money and what percentage of ownership, and then there is a provision about the transfer restriction. And then management, how to manage this company, how is the shareholders meeting or board meeting, or what about the officers, like representative director, or, you know, who's going to nominate and what's going to happen. And then, you know, there are provisions about, you know, related agreement, how it's going to be entered into, when it's going to be entered into, and things of that sort. And other things, the fiscal year, and, you know, what kind of accounting is to be done, and things of that sort. Okay. And then about the termination, you know, see reps and warranties, you don't need one. Then there's a when can this terminate, and when this terminate, what's the consequences? Will there be put option or call option or things of that sort? And then usually ends with a bunch of miscellaneous boilerplates that are usually goes into. And then obviously there's a governing law, and dispute resolution mechanism is necessary. What's going to be the governing law? It's usually the laws of that country. But even though the laws absolutely of that jurisdiction applies automatically and mandatorily, you can still have laws of New York or some other laws to govern the joint venture agreement, but usually it's that the laws of local locality where this company is established, because there are so many mandatory laws that applies. And then you want to say dispute resolution. How is dispute resolution is going to happen? You want the local court or arbitration. Is there a dispute resolution section here? Or did I miss it? No, I don't see it. Right? That's a very important section that should be included here. Yeah, it's strange. Well, anyway, if it's not written, then you can just it is it is assumed that the law of locality probably will govern. And then dispute resolution, obviously, unless you specifically agree to arbitration, the arbitration cannot be done. And you have to just go to the local law, having jurisdiction over either the company and so on and so on. Okay? Yeah?
How about the distribution of the cost and expenses between the parties?
Yeah, cost and expenses, obviously, unless it is specifically agreed, I guess the assumption, the default rule would be that each party would be responsible for its own cost. Sometimes it is written specifically in the agreement, but even in the absence of it, I think it would be hard to say that my lawyer's fees to claim that you have to pay for my lawyer's fee, right? In the long form, usually, they say that, taxes will be the responsibility of whom and, things of that sort. But that's probably commonsensical that probably you do not need it, yeah. Okay, guys, any questions?
What is the difference between director and officer? Like, usually the representative director is the CEO.
Officer is a broader term than directors, right? So, you differentiate directors because directors are the member of board of directors. But officers could be anyone, It just could be executive director without being member, just called 이사 kind of thing, right? Yeah. There are many 이사s in this 이사, 상무, and all those executive roles, right? 전무, 이사, 상무, 전무. But they are not necessarily a member of the board of directors. The board of directors has the ultimate responsibilities in management of the company, not the executive directors.
Like one person can be the representative director while another person can be your CEO. Is that?
No, representative director is just a legal title. Okay, it's a legal title. Whereas CEO, terms like CEO is just an internal executive title. Usually the representative director is the CEO, but I have seen other arrangement where representative director and CEO are different. But when we say CEO in U.S. terms, president, CEO, whatever, then we usually assume that CEO has the right to represent the company. But talking about legal title, it's the representative director in Korea. So the representative director has the legal power and authority to represent the company and bind the company. When that he doesn't need no power of attorney to sign. Okay. Any other questions? Okay, good enough. Thank you, and I have to say that I enjoyed having this period of time with you. I know a lot of you, I think most of you is having an exam starting next week, so good luck with your exam. So for the third year, good luck with your bar exam. And good luck, Philip, with your various roles in your assignment. It's a pleasure meeting you, and I hope to see you outside of class whenever you guys are done. We might have reunion, and we'll let you know, when that will be. Okay? Thank you. Good luck. Thank you.